Okay, so a few people have asked me if I can comment anything about this potential defamation spat between Rupert Lowe and this chap called Femi. And yes, I can offer some thoughts. Now, first of all, just to say, I'm just commenting about the spat generally, and I'm certainly not suggesting anything untoward to Mr. Lowe. But sort of, let me just explain what it's about. This guy Femi, he's a sort of commentator on social media. And he posted like a tweet with an attached short video where he said 40% of Reform MPs, according to Reform, are violent criminals. And he based that on, first of all, there's one guy who actually does have a conviction, but of course Mr. Lowe has not been convicted of anything. There's been certain accusations made against him, which he categorically denies and has put forward a lot of commentary to support that denial. But does the fact that Mr. Femi said, according to Reform, does that get him off the hook? Well, no, it doesn't. First of all, repeating that somebody has been accused of something. Now, you might say, well, it's factually correct. If somebody says, I am just saying that person A says that person B has committed a crime, well, if person A has said that about person B, then that's true. So how can that be defamatory? But the whole point of defamation is, you know, it's about lowering people's reputation in the minds of right-minded people. And just by sort of pointing that out, you're effectively drawing attention to the allegations. So it's never been a defence merely to say, I'm just reporting what other people say. Similarly, it's why just, you know, saying allegedly does not get you off the hook. However, does Femi have any defences? Well, he has a few. I mean, first of all, Rupert Lowe would have to show that he has suffered serious harm on the back of this comment. And serious harm now, after a case called Le Show, you actually have to evidence that. You have to show with evidence that the allegation has either caused you serious harm or is likely to cause you serious harm. However, if you accuse somebody of a criminal offence that can attract a sentence of 12 months or more, then generally the courts say, well, that is evidence that you've caused this person serious harm. So what would be the meaning of the tweet? Well, it's a violent criminal. So it doesn't actually specify an offence. Now, I suppose you could say that a common assault makes one a violent criminal, and of course the maximum penalty there is only 6 months, so that wouldn't count. So what would the judge, it's be up to a judge to decide what the meaning is. It may well be though, because you know the phrase violent criminal, that's clearly suggesting that you know, arguably that this is something more than just a mere bit of common assault. However, so that's possibly that box ticked as well. But does Mr. Femi have any defences? Well, obviously he could say, well, you know, these allegations are true, although he doesn't seem to be claiming that. And the thing to remember here is you can't just take the tweet, the words in isolation. You have to look at the whole thing, being an antidote. So you have to look at what he says in the video. Now in the video, he's just reporting on what Reform themselves say. And he does point out and say that Mr. Lowe has denied the allegations. So it may well be he would have a public interest defence. But that's a two-part test to say, because the thing with public interest is you'd actually have to prove the allegation is true. You just have to show that, first of all, you're commenting on a matter of public interest, but also, this is the bit that people forget, the second limb, that it was in the public interest to report in the way that you did. Now, I think the first limb would be satisfied. Clearly, somebody standing for public office, you know, their actual character is clearly a matter of public interest. But was it the public interest to actually repeat these allegations in the way that they were done? I mean, we used to have what we used to call the Reynolds defence, which was a sort of effectively a checklist. You know, have you offered the person a right to reply? Have you checked your sources? All that sort of thing. Now, Under the 2013 Defamation Act, I'll just turn it to the sun to get a sort of slightly better image. Under the 2013 Defamation Act, the Reynolds Bell defence has been abolished. The idea is it was to give additional protection to journalists, and the courts don't distinguish between, of course, professional journalists and citizen journalists. So the idea is it's meant to be a lot easier to report on things. But was it in the public interest to make the allegation in the way that he did? Well, he did sort of say what he was doing. He referred to the documents, to Reform's own statement. And the fact of the matter is, any press association, any journalist can probably report on the fact that that's what Reform themselves are claiming. They're saying we've removed the whip from this person because of these allegations. But of course, at this stage, they are merely allegations. So, does the according to Reform, because even arguably Reform themselves don't say yes, he definitely did it. They are just saying, we are investigating. Now, when it comes to allegations of criminality, we have what we call chase levels. Chase level 1, he definitely did it. Chase level 2, there are strong grounds or grounds for suggesting he did it. Chase level 3, there are grounds for investigating he did it. I mean, it's more of a spectrum really, because you sometimes say, oh, this is chase 2.5, because it's somewhere between, suggesting there is grounds for believing he did it and strong grounds and all that sort of thing. But this appears to be now arguably saying somebody's a violent criminal. That's chase level 1, because you're not saying according to Reform 40% of their MPs or 20% of their MPs are suspected of violence. It seems to be specifically saying that yes, they committed violence. So it's a chase level 1 probably. But the public interest defence, it is quite a strong one, and courts are very reluctant to interfere with, as they say, editorial decisions. So basically what am I saying? Well, typical barrister style, I'm saying it depends. I mean, if I was advising on this, whether it was for the claimant or the defendant, I mean, it's a tricky one, this, because it literally is, at this stage it seems sort of like 50-50. Obviously, if Mr. Lowe were to issue proceedings, the first thing that would happen would be the meaning hearing. Now, the way that happens is the judge sits down and says, okay, I'm just going to look at this as if I was a regular human. The hypothetical reasonable reader. That's somebody who is neither overly naive but not too prone to scandal and gossip. So the judge will look at that before he even looks at, or she, it's probably this Lady Justice Stain, will probably look at that before even reading any of what we call the pleadings, the claim form, the particulars of the claim, where Mr. Lowe would say, I say it means this, it's an allegation, I am a dangerous person, a violent criminal, whereas Mr. Femi would no doubt say, no, the meaning is that he has just been suspended from the party and there's an investigation. But the judge would come down and say, well, I think this is what the meaning. The judge could also look at things as to, is this a matter of opinion? Well, it's clearly not. It's not being put forward as, in my opinion, he's an unfit person for office. I mean, you could say that. You could say something like, even in view of these allegations, true or not, whether it amounts to criminality, I suggest this means that this is not a fit and proper person. And that would be an opinion. But that doesn't apply in this case. It's clearly an allegation of fact. But what he's saying is, I am just reporting on what Reform themselves say. So you'd have the meaning hearing, and chances are a judge might come back and say, I find this is an allegation of violent criminality. One thing they could do at that hearing is say whether or not it crosses the serious harm threshold. So I think this is one of these cases where if somebody was to issue, you'd have the meaning hearing, and then the judge would no doubt come back, and at that hearing could also say we'd apply to strike out because he hasn't evidence that this has actually caused him serious harm. Also, if it has caused him serious harm, well, what if other people are repeating the allegation? I mean, is it like, well, it's not just me causing serious harm, everyone's saying this, so you have to sort of apportion all that sort of thing. I mean, it's not a defence though just to say, well, loads of other people are doing it, you can be sued yourself, but then when it comes to working out the damages, you would take into account, well, have other people already sort of said this, and you try to do some weird apportionment. know, because otherwise you could get double recovery. You could sue everybody who said something about you and said that all amounts to serious harm, and I want some compensation from all of them, you know, and you could end up like with multiple recovery just because lots of people have actually said it. Oh, that's quite a nice shot with the sun behind me. I'll keep that one as I head back to the Winnick because it's blooming freezing up here. So yeah, so those are my thoughts. Like I say, you know, Mr. Lowe has denied these allegations quite strenuously, and he's provided lots of material to suggest that the investigation itself or his suspension is somehow flawed, because apparently, you know, the alleged victims themselves are coming forward and saying we didn't have a problem with him, it was all about somebody else. There's been all this stuff about, well, we've got a KC to advise on this, and there's all arguments as to whether or not the KC's advice is being reported is actually the advice that they gave. So yeah, so it's an interesting one. So basically, this reminds me when I used to write advices for insurance companies. What would I put this as? I'll be honest, I'd probably put this one as category C. It used to go from A to C. It used to go from A to, hang on, A, B, C, D, E. It used to go from A to E, which was A was, yeah, we're bound to win. B was, we'll probably win. C was, it's 50-50. D, we're probably going to lose. E, we're definitely going to lose. I think on this one, I'd have to grade it as a C. So yeah, I mean, subject to how much money people want to throw at this, probably worth, you know, if it was to issue proceedings, it'd at least get to the meanings hearing, where no doubt Mr. Fenley would also apply to strike out on the grounds that hasn't shown serious harm, and also this is clearly a matter to report in the public interest. But there you go, so that's my $0.02 worth. I'll keep an eye on this story, and as things develop and if there's an appetite for this, I'll report back. So there you go. As always, hope you found that vaguely informative, vaguely interesting, vaguely accurate. Where am I? I'm just wandering up and down on Penty here. I'm actually doing a load of work in the Winnick. I've got loads. That's why I've been, sorry for the dearth of videos, but I've just been so busy recently with work. And if you're anybody like clients or solicitors chasing me or anything like that, please be assured that I'm just about to deal with your phone message or email. That's my biggest priority as I get back inside where it's nice and warm.